So we wanted to organize this event because it's very timely and very relevant discussion as we wait for a court decision to be made about the Robinson-Huron Treaty case coming up in December of this year. Our esteemed guests will be going through the history of this historic and potentially precedent-setting event. So I won't be going into any detail about the case or what they're going to be talking about themselves in my introduction here, but we are very honored to have these three panelists who have been very intimately connected and instrumental in bringing the annuity case to court. Today's panel format will consist of each panelist presenting from their perspective and expertise, followed by a panel discussion and question and answer period. And so it is my honor now to introduce each of our panelists. Starting beside our moderator, Brock Pitawanakwit, the chair of our Indigenous Studies program here, is Art Patatagoose, who is a member of Atikameksheng Anishinaabe, a retired professor specializing in Anishinaabe culture. He has served his community as Gima and as a council member. He is viewed by the Atikameksheng as an elder. Art was employed by Atikameksheng community in multiple roles, including in claims research. He is schooled in Anishinaabe cultural practices and has worked in the profession of urban planning as a project leader. Art continues to work as a consultant and lecturer, assisting Indigenous nations of people in protecting rights and interests. Beside him, I put my people in the wrong way here. It was supposed to be Stephen. Sorry. So beside him, we have Mike Ristol. Mike is a citizen of Nipissing First Nation near North Bay, Ontario. He lives with his wife Brenda, who has joined us here today as well, on the Nipissing First Nation. Mike served his community on council for 17 years. Prior to that, he was a volunteer on the board of directors at the North Bay Indigenous Friendship Center. After working for 31 years in the railway industry in North Bay, Mike joined the staff at the Union of Ontario Indians at Nipissing First Nation, for a further 11 years. During this period, Mike worked as a volunteer with the Robinson-Huron Treaty Chiefs on the annuities case for 26 years. He continues to work for the treaty today. Currently, he is the chair of the Robinson-Huron Treaty Litigation Trust Fund, having been appointed by the members of the trust in 2010. The trust was mandated to bring the annuities case to court. Beside him is the Honorable Stephen O'Neill. Stephen's legal career spans nearly 39 years. He has dedicated his career to working as a judge in Northern Ontario and working in private practice for First Nations. In addition to serving 16 years as a judge of the Ontario Supreme Court of Justice, he has been general counsel and has worked in land claims, mitigation, and negotiations. He has experienced firsthand how mitigation and alternative dispute resolution can contribute greatly to the settlement of long-standing claims and disputes. He is looking forward to constructively assisting in mediations and alternative dispute resolution processes involving the Crown, industry, and Indigenous peoples. Stephen graduated from the University of Windsor and spent 22 years in private practice before becoming a judge in 1999. He was a past executive member of the Aboriginal Law Section of the Canadian Bar Association and a past member of the Canadian Judges Conference and the Ontario Supreme Court Judges Association. He has written extensively on First Nations issues and has also spoken in various venues across Canada with respect to Indigenous and Crown relations and in reference to the fundamental importance of the principle of reconciliation. Stephen is married to Shirley and they have 4 children and 4 grandchildren, and in his spare time he enjoys canoeing, running, and cross-country skiing. And so we also are very lucky to have our moderator, Brock Pitawanakwit, as I mentioned earlier, who is the chair of the Indigenous Studies Department. And just really quickly, I would like to acknowledge that we do have Chief Scott McLeod here from the Nipissing First Nation, and so I just want to say welcome and thank you very much for coming. And with that, I would like to open it up for Art Patatagoose to start with his remarks.
In coming to a session like this, where we are having the opportunity to speak to citizens from Ontario and Canada, we're having to think about this time. It's been a long time in coming to have this type of gatherings. Over the years, and growing up at home close to where the university is sited, I was always reminded by my parents about being an Anishinaabe. We think today about some of the language which is used to describe who we are. It's always been clear to me about where it is that I come from and who I am. So terms like colonized other, Indigenous, Indian, Aboriginal, that kind of terminology, we've got to take it and throw it on the wayside, because it doesn't belong. Canada is having to come to face reality. There are nations here, and we've been here for a long time. We go back to the time of that last ice age. Our stories talk about those kinds of beginnings of our past being known in our stories. So we were hearing even before that, because we see that in some of the artifacts, saying that the tools that were being found were coming from people. I look at those as being my ancestors, those that came before. But over the years, in coming into contact with the outside world, in our language we have story, we have record. When we first came into people from Great Britain, we coined this term Shognosh. That language says this man that came off that boat, those people that came off that boat were hurting, they were sick, they were needing help. And according to my law, I was obligated to reach out and take care of them, provide them with that comfort and home. So we did that. We hear that from the stories of our relatives that come from that East Coast territory, our brothers and sisters. Through time, we have been invited, and this is in part where some of our story is registered and the work scrolls. Peter O'Cheese used to come this way from the mountains. He'd come and visit with us to remind us about our past. And this was before the coming into being of that World Proclamation. During that time, we just preceding the Royal Proclamation, Britain and France had been at war, and our people were being dragged into this conflict. And we were saying, I'm sorry if those are your games. That has nothing to do with us. But we are being pulled into this conflict where war is being waged between nations. And we don't want to become part. It doesn't involve us. That's in your homeland, this is our home. So we took care of ourselves. We took our birch bark scrolls, put them in bundles, and moved them to the west. So we see the O'Cheese community today out in the mountains of Alberta. And we see some of our people down in Mexico, the journey where these birch bark scrolls were carried to secure them, to protect them, and the knowledge that they contain. So when we started to sit down with the people from Great Britain, with whom we made that first treaty. But before we made the treaty, that 1763 time frame, that period, we had a man here coming from our territory, Chief Pontiac. Chief Pontiac was aware of what was happening to our people, our sisters, our brothers, down in the east coast of Turtle Island. Today we talk about the United States, the eastern seaboard. But all the people who were down there, our brothers and sisters, and they were encountering that kind of a removal from their lands, being thrown out of their own house, having to vacate their lands and move to the west. We became aware of those conditions, and we were saying we do not want to have this come to us here in our home. Our people were aware. We had traveled, we had visited. So in that time period, our people were traveling down there. In Montreal, Niagara Falls, Quebec. We were engaging with the people in those regions, visiting, trading. And in that 1763 time period, Pontiac began to evict people from Great Britain because of that behavior which was being shown to our peoples. He threatened, he said to them, we're going to send you home. So the Crown cried mercy. Cried for mercy. Please don't evict us. So we said, you've got to do something to change that. So we see this law being issued. Today we recognize it as being world proclamation. The first law coming from Great Britain, the mother nation, the mother country. And in that law, it says very clearly, we recognize, we accommodate that there are nations here in Turtle Island. We being among them. And they were saying, great frauds have been committed in my name. I'm facing that horror that our people will be subjected to. And I'm facing the possibility, in terms of my interest in wanting to expand my empire across the face of the globe, I may not have a home here in North America. These newly discovered lands, these rich resources. So when you think about that, they were aware of what this place was having, the richness of the land, the richness and wealth of the people. They were concerned about making ties, making long-term arrangements to continue to have access. So they issued this law. We take away all the power from those officials who think they have power and authority, who think that they have permission from me to go out and take over lands and territory from the inhabitants out here, the nations and peoples. So our people said, no, you do not have this kind of freedom. That's why we are removing you. So to show you my intent, my honesty about wanting to become your friend, I make this law to say that no one can issue any kind of permission, grant, lease, sale of land, which is your home. I take that from them, and I now make it the law. Before anyone can come onto the land of your people, they first must make a treaty. So they came. with this understanding that there's rule of law that's been laid down about process to be engaged. We witnessed that. We helped to put that into place. It was our action that made it happen. That's part of what you don't see today. It's now arising because of this kind of forum. The history of our people is being learned from our vantage point about events that has occurred. So in 1763, we see that law being brought forward. 1764, the following summer, we assembled at Niagara Falls. Word was sent out across the lands inviting the leadership of the nations to come and assemble to talk about engaging in the making of a treaty. But we did two things at that time. We made treaty among ourselves as nations. We sat down and we made treaty. We see a belt being created, which comes from that action. 24 nation belt. That one was brought into the court here in Sudbury, laid down there at the front of the court by our delegates. It was beautiful to see when we walk in there to have those belts in that court on the table. Because it was reminding Great Britain about the journey that they have traveled with us, about the transgressions which have occurred. And we laid that one down. Nations, what did we do? We reached out to protect one another as indigenous nations, Anishinaabe, Cree, many nations. And we extended the interest and right of our people. To not just be stuck and confined here to the Great Lakes region. Our interests spread out across the land to the salt water. The Atlantic, Gulf of Mexico, Pacific, the Arctic, completely around the whole of Turtle Island. Those are our lands. Those are our territories. We made this agreement among ourselves because we have those freedoms, we have those jurisdictions, we have those responsibilities to take care of our own. And we did that. Today, within that court, we did not want to admit, question whether or not that was okay. It's not for them to decide. It's for our people. We make decisions to take care of ourselves. So following the making of that treaty among ourselves, we sat down to make a treaty with Great Britain. That's what we call the Silver Covenant chain. One end of the chain anchored over in Europe in the house of Great Britain, to which all the nations of Europe are invited to come and live in peace here to Turtle Island with us. The other end of the chain is anchored here in North America. We come together, bring the world united into one. That one's registered in the teaching about the dish of one stone. One race, we all take our life from. That's one mother. In our language we say, the life that I have, the person who I am, the life is coming from my mother. She takes care of me. That's what being Anishinaabe means. That's who I am. I look after that kind of knowledge, and I try to live it to the best of my ability. So when I go out and talk, this is the kind of story that I share. We invite the world come and leave it on in peace with us. Because we know that they're living in conditions which are challenging. Leaving homes where there's poverty, destruction, evil. And they come here searching for a new place to have a home. And we invite them to come and live. And there's a condition. That's where we get to see these ideas about children walking about. Your responsibility is to look after your teaching in the way that you're going to care for your people. We look after our people, following our customs and practices in our teaching, in terms of defining ourselves as a missionary. That's what we do. And we struggle. Our way of life has been undermined through things like the Indian Act, this piece of legislation, ethnic cleansing, the blood of our children. Try to pass that on. Canada comes into interfere. We can't do that. Sorry, it's not your place to decide. We decide. So it's our authority as people, as a nation. To look after ourselves and how we find our citizenship and to decide to the laws. We haven't given up that responsibility. Can you look inside that treaty document? It doesn't say we give away citizenship responsibility in authority. Keep that. What it does say is that we give permission for the newcomer to come and live here with us in our home. And it lays down economic responsibilities about what is to be done by the newcomer coming into our house. They can access, they can use, what's the cost? That's what's been fighting at the core of the court case. What is the nature of this cost? How is it to be paid? What does it look like today? Because in 1850, when the treaty was made, we did not know at that time what kind of growth was going to occur. In the case of our community here in Tikmekshing, when they talked about our land base, the understanding was that no one would ever come because we were too remote, too isolated. So they didn't want to survey our territory. But through time we see sadness come out. 1887, our court, in a court case that was held. Our community was dragged into that setting without any kind of legal counsel, without any kind of guidance, to testify in a dispute between Canada and Ontario. We suffered a loss, a very big loss. Today our reserve land base that we see being described on the block of land, talk about a reserve. Under the law of the Indian Act, reserve says it belongs to Canada. When we sat down to make treaty, we set a block of land aside called a reservation. We made the reservation, not Canada, not Ontario. We decide what size that land base is. We define the boundaries. So when the surveyor came and we told him what to survey, he said no. He didn't want to survey this larger block that we had created because he didn't have enough money to do the job. But there's record about him acting alone, going against the consent and wish of our people. So we ended up with this block of land called a reserve, which is about 70 square miles, plus or minus, depending on whether there's water and how much is chopped off from that base. But our reservation is more in the range of 1,500 square miles. It's been diminished in size, not by our choosing, but by the reach of the treaty. So today, we're not talking about that side. We're talking more about the monetary side. What is inside this treaty that Canada gains, that Ontario gains as a result of making that treaty? That's just one item. But each of the Canadians across the region has some kind of claim that they're going to bring before the courts, before Canada and Ontario. Because that's part of this aspect of reconciliation. What kind of a future are we going to define for our people today? Because my children have suffered enough. And the people have said that. We will get that dispute for that. Coming together. Protest. Fight more. Enough is enough. We're looking at being equal as peoples within this new place we call home. We're looking at Canada today. What kind of a future is it going to be for us? We want it to be positive. And that's what we're working to create.
Ani, bonjour. Josh Cause. We sing Don't You Bob. She can go them. My Ojibwe name is Muskrat. I'm from Nipissing First Nation. And I am a turtle wearer. And the reason I say my name and who I am in the language is because of a teaching I received from an elder a number of years back. He said to me, if you want the ancestors to hear you when you speak to people, you should tell the ancestors who you are in the language, because they don't understand English. Some of those ancestors are very, very old, and they don't understand the English language. So if I want to reach those people and tell them who I am in this room, because Art lit the sage here and smudged the room and smudged us all, and in so doing, he calls on the ancestors to come into the room with us so that we can talk in friendship together. So that's why I introduce myself in the language. I'm not a language speaker, I'm not a lawyer, I'm not an academic or a scholar. I'm just an average Joe. That's who I am. But I've been working on this case for a long time, and I'm sorry that I have to stand up because my presentation to you are on these slides. And I'm sorry, Stephen, if I have my back. I'll try and turn around every now and again so you see who I am. So what I want to do is I want to tell you, and I spoke with Sarah some time ago about this gathering, about what I should say here to you today. And what Sarah said, maybe you should talk about the trial. Art talked a little bit about the trial. He talked about us being in the courtroom here in Sudbury. Not the actual courtroom, but we made a courtroom at the Radisson Hotel here in Sudbury. And we had our case, the final weeks of our case here in Sudbury. The case that we're talking about here goes way back to the early 1850s. When the leaders in the communities appealed to the Crown representatives that they had not followed through on their promise in the treaty. The treaty said that if you gain more wealth in the territory, then you should augment the treaty annuity. The treaty annuity was set at $4 per person per year back in 1874. It's never risen since that time. despite the fact that in the Robinson-Huron Treaty Territory, there was immense wealth that was gained by the Crown over those years. So the leadership in the First Nations said, we don't agree with that. We need to settle this. We have this grievance. And it took a long time. As a matter of fact, 144 years since the last increase in the annuity. So we decided, I shouldn't say we because I wasn't a chief and I've never been a chief. The chiefs decided that the only way, after all of those years of appealing to the Crown representatives, it was falling on deaf ears. So the chiefs said, we're going to take this into the court and see about getting justice, because the court said we are the appeal for justice in this land. So we appeal to the court for justice in our treaty. So the chiefs put together an organization called the Litigation Fund, a trust that would lead the charge into the court and work with the legal team to bring this case into court. So that's what I'm going to tell you today. A little bit of background. After the RHT Robinson-Huron Treaty was signed in 1850, the annuity was increased once in 1875. I said 1874. It was somewhere in that area. And the amount was £1 provincial currency per person. That amounted to about $4 per person. And has not been increased since that time. The RHT Trust filed a statement of claim on September the 9th, 2014, here in Sudbury, in Sudbury, yes. That was Treaty Day. That was the day when we acknowledged the treaty was signed by the Ojibwe people and William Benjamin Robinson on behalf of the Crown. The case is being heard together with a similar action brought by two First Nations under the Robinson Superior Treaty. You may have heard about the Robinson Superior Treaty. Several of the First Nations on the north shore of Lake Superior signed the treaty at the same time, and it became known as the Robinson Superior Treaty. Those people had already an action going into court. So when we filed our our complaint into court, we talked to the Robinson Superior Treaty people, and we said, well, let's do the two actions at the same time. Yes.
I'm going to teach you off a copy if you'd like to
Thank you so much. You know, I can now sit down. Thank you. Although I like standing up. I should have brought my guitar. Chief Scott. But it's sang a song. And before I continue, I just want to acknowledge Ogama Duke Pelche is here from Wikwemapong as well. We introduced Chief Scott a little earlier, and Ogama Duke Pelche is in the room as well. I don't see any other chiefs there, but if you're there, put up your hand and we'll let you know, and let everybody know that you're here. So, the 21 First Nations, that's slide number 2. 21 First Nations under the Robinson-Huron Treaty formed a trust to pursue the court action against Canada and Ontario. And the case involves the augmentation clause of the treaty, and it says, should the territory ceded at any future period produce such an amount as will enable the government of this province without incurring loss to increase the annuity hereby secured to them, and then in that case the same shall be augmented from time to time. I'm here to tell you today, it's never been augmented since 1874. That's why we're in court. So, I'm at slide 3. After the treaty was signed, the annuity was, I already went through that, so I'm sorry, I'm repeating myself. Okay, slide 4. In July of 2016, the Robinson-Huron Treaty Trust filed a notice of motion for summary judgment on the claim, on part of the claim in the statement of claim, because it is such a huge case that the parties in discussions decided maybe that should be taken a little bit at a time so that we can move the case more quickly through the courts and make it easier on the parties. So The plaintiffs then, what we did is we moved a declaration for summary judgment. And that since 1850, the Crown has been and remains legally obligated under the Robinson-Huron Treaty of 1850 to increase the annuity under the treaty from time to time if the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss. And that the size of the increase of the annuity is not limited to an amount based on £1 per person. Court hearings began on the summary judgment motion on September the 25th, 2017 in Thunder Bay. The reason we went to Thunder Bay is because as I said earlier, the Robinson Superior Group were in court with us, and we wanted an opportunity for the people in that area to come to the court and hear some of the court proceedings. So that's why we went to Thunder Bay. The litigation is being heard in 3 stages. In stage 1, does the augmentation clause represent a legal obligation over which a court can exercise judicial authority? We're waiting for a decision on that stage of the litigation. We hope to receive that decision by the end of the year, in December. Hopefully it's earlier in December rather than later in December, because people move around quickly at that time of year. Stage 2 are technical defenses and respective Crown liability. And if there is a legal obligation, if stage 1 says there's a legal obligation for the Crown to honor this, then we move to stage 2. In stage 2, the Crown brings forward these technical defenses, which are limitations and latches. That's delay. As I said earlier, I'm not a lawyer, and if you have a question about what the heck that is, here's the man who can answer it. So, you know, it basically says you took too long to bring your case to court, so you can't bring it now because it's too old, it's too long ago, and we can't deal with that in the court. Well, we're going to bring our arguments about that. Res judicata means that there's already been a case in the past that dealt with this issue, and they're going to rely on that case. In the past, there was a previous ruling on the annuities arbitration, 1895. I think I was there in the court then at that time. Canada and Ontario were playing ping pong with the annuity. Who was going to pay for that? You know, because Canada was saying the province collects all the money, and Ontario was saying, well, you're responsible because you're the representative of the Queen, and you're responsible to pay the. Anyway, it turns out that the case was settled in that ping pong game. Not about the annuity, but about that ping pong game as to who's going to pay. That's what that was about. The other one is which Crown is liable. So, you know, we know that ping pong game. Stage 3, quantum of financial compensation. So if we're successful at stage 1, the Crown is liable, and if we're successful at stage 2, those Crown defenses go away. The third stage is quantum of financial compensation. How much does the Crown owe to the First Nations back to 1874, 1875, when the annuities should have been increased because of the revenue that was gained in the territory? That's our argument in the court. Stage 1 is about justiciability. The court granted an order permitting live streaming and archiving of the proceedings. This is a first in Ontario, in an Ontario Superior Court, for a case to be live streamed and archived. And Justice Hennessy agreed to the presentations that were put forth by the parties on that. 78 days of trial were had between September 25th and about June of 2018 in 4 different locations. We started in Thunder Bay, we went to Manitoulin Island, we went to Garden River First Nation, just outside of Sault Ste. Marie, and then we came to Sudbury to to do the last parts of the trial. A total of 20 witnesses gave testimony in that trial. The RHT plaintiffs presented five expert witnesses, 4 elders, 3 chiefs and leaders. The RHT plaintiffs had 2 experts. Canada had 3 experts. Ontario had 2 experts and 1 layperson presenting evidence in the court. The elders protocol was developed for the taking of elders' evidence. What we had a concern about was these elders would go into court and they very well may be cross-examined by lawyers in the court about their evidence. So the lawyers got together and developed a protocol how to treat the elders in the courtroom based on the submissions of the parties, and that turned out really well. The elders were treated very well in the court, and we're very proud of that. Also, at the first time in court, Elder Rita Corbier from Huron, unceded territory, did a translation of the treaty. She took the treaty document as it's written in English. She translated it into Anishinaabe, and then she translated it back into English. Because through that process is what really happened in 1850. Because the people there didn't understand English, the people who were there didn't understand English. So somebody needed to translate what William Benjamin Robinson was saying. So they had to translate it into Anishinaabe for those people. And then today we want to know what the Anishinaabe think or understand what their idea is about the treaty. So that's what was really helpful. This was a really important part of the case. Elder Irene Stevens, she talked about oral history, about how the Anishinaabe people remember things. There was no books. There was no art. Elder Art talked about the birch bark scrolls. But other than that, there was no books to remember things. People did that by memory alone, by telling stories. And they passed those stories along from family to family, from person to person through the years. And those stories stayed alive. And that's how the history of the Anishinaabe were maintained at that time. So Irene Makadavin from Sagmuk, Anishinaabe, told those kinds of stories to the court. Elder Fred Kelly is from Treaty 3 area. I can't remember the name of his First Nation. Fred Kelly is an expert on Anishinaabe law and treaty interpretation. He talked about that. He talked about the Anishinaabe language and about the things that are important in Anishinaabe law that led to the making of treaties in this country. Anishinaabe law on treaty interpretation was put forward by the RHT plaintiffs through the elders and experts, guided by respect, generosity, reciprocity, renewal, and sharing. And you'll recognize those, at least Anishinaabe people will recognize those as very important values in our society, in Anishinaabe society, and in other societies from Indigenous people in North America as well. They're also very important values in non-Native society, non-Indigenous society as well. So those are the key things that were part of the treaty making at that time. Anishinaabe was used to interpret treaty terms and to establish Anishinaabe laws, concepts, and ceremonies. We did a lot of ceremonies while the trial was going on. We had an elder that was helping us. His name is Leroy Bennett. He's from Sagmuk, Anishinaabe. And he led us in pipe ceremonies, smudge ceremonies, sweat lodges, in the court, gave us a lot of teachings, and the court really appreciated that. As a matter of fact, the judge, Justice Hennessy, and the non-Indigenous lawyers that were representing Canada and Ontario went into the sweat lodge. They went into the sweat lodge and they talked amongst themselves in the sweat lodge. I don't know what they talked about, but they did. And that was really a big part of preparing all of those lawyers for the case that they were to deal with. Our key experts in the case were Jim Morrison. I don't know if many of you know who Jim Morrison is. He's one of the foremost authorities on treaty making in Canada. He has the making of the Robinson Huron and Robinson Treaty, Robinson Huron and Robinson Superior treaties in his head. He's done this research. As a matter of fact, he wrote a document for the Royal Commission on Aboriginal People. Thank you. In 1996, Alan Corbiere is from Chagin First Nation. Dr. Heidi Bulker is a PhD from University of Toronto. They talked about the Anishinaabe historical perspective. Getting a little dry. Dr. Heidi Stark talked about Anishinaabe law. She's an expert on Anishinaabe law. She's an Anishinaabe Kwe from, I think it is, sorry, Dr. Heidi, I'm saying Wisconsin. I'm not positive on that, but I'm trying to remember now. But anyway, Dr. Heidi Stark talked about the Anishinaabe law. Dr. Carl Beale, one of the foremost economic historians in Canada, worked on our behalf, did some research on our behalf, and told us about the historical perspectives of the Robinson-Huron Treaty Territory. Came up with some numbers that kind of frightened Canada and Ontario in his research. So what's next for the trust? So we went through all of that, and the court case ended in June of 2018. Basically, at that time, what we did is we had our lawyers present final arguments in the case in June here in Sudbury, and now Justice Patricia Hennessy has gone away to write her ruling on stage 1 of the trial. So what's next for the trust? Regardless of what the result of the decision is in December, our 21 First Nations are open to settlement discussions directed at a fair and just settlement of this whole case. We're always asking Ontario and Canada, we're ready and willing to sit down at a table and settle this if you want to do it that way. And so we plan to continue to keep our citizens and our neighbors updated throughout on social media. Please follow us on Facebook, Robinson Huron Treaty Trust, Annuity Case. You'll find that on Facebook. And on Twitter, Robinson Huron Treaty at 1850 Robinson Huron Treaty. If you want to catch up on the litigation, you can go on the live streaming site, which is indicated there on the screen. You can find all the recorded testimony there. It's very lengthy because we had all of those days, 78 days, I think it was, of testimony. There's a lot of talking going on there. So, you know, if you want to see that and listen to it, it's there for you to check out. And so we'll continue to follow up on our Anishinaabe laws in pursuing a just resolution for our case. Do you have any questions? We can maybe deal with that a little later after Justice. Thank you very much. Miigwech, Steve.
Thank you.
Good afternoon, everyone. I hope I don't block anyone move around. So my name is Stephen O'Neill, and I work with Nawaldabo Corbiere. David Nawaldabo is Mike Fisher, Diane. That's David Nawaldabo, Mike Fisher, and Diane Corbiere from Chagin. They put a legal team together of lawyers across this country to launch and present this case. And when Sarah spoke to me, I said, well, The decision is under reserve. We have to really choose our words carefully. We have to respect the court process. But I thought that I could help a little bit, maybe by speaking a little bit about the treaty-making process in Canada. What is a treaty? Why are treaties important? What is it? What is this background? And can everyone hear me okay? So first slide, please. Justice delayed is justice denied. And then justice anywhere is a threat to justice everywhere. Martin Luther King. Justice trumps the law. Law is a subset of justice. Law must give way to justice. Next slide, please. In 2000, the Ontario Court of Appeal, in a case called Chippewas of Sarnia, handed down a major ruling about the Royal Proclamation of 1763. You'll find that you can Google Chippewas of Sarnia Baron case. You can find the 2000 year 2000 decision in paragraph 53. You can read about the importance. So Elder Art spoke to us about the Royal Proclamation of 1763 and how it prohibited private purchase of Indian lands and required that alienation of Indian rights in their lands had to be through a treaty-making process. And the Royal Proclamation is part of the Constitution of Canada. Next screen, please. I'm quoting from paragraph 54 of that decision, and I think it's worthwhile to read it all. And some of this has changed a little bit with the evidence of the court case. Ogama Pelche is here, Ogama from Okamakwong, and Chief Cloud is here. I honor and recognize him here today. And Elder Hatada, who's going to talk about the covenant chain and the two-row wampum. But at that time, the court wrote that after setting out its policy in the Royal Proclamation, the Crown took extraordinary steps to make the First Nations aware of the policy and to gain their support on the basis that the policy set down in the Royal Proclamation would govern Crown First Nations relations. In the summer of 1764, at the request of the Crown, more than 2,000 First Nations chiefs representing some 22 First Nations, including chiefs from the Chippewa Nation, attended a Grand Council at Niagara. I'll let you just read the rest of that screen. Chiefs in turn promised to keep the peace, deliver up prisoners taken in recent hostilities. The singular significance of the Royal Proclamation to the First Nations can be traced to this extraordinary assembly and the treaty it produced. These are 5 judges from Ontario's highest court writing this decision, and that decision was appealed to the Supreme Court of Canada, and leave was not granted. Therefore, that is a binding decision in law. Next screen, please. The First Nations prepared an elaborate wampum belt to reflect their understanding of the Treaty of Niagara. The belt described the relationship between the Crown and the First Nations as being based on peace, friendship, and mutual respect. The belt symbolized the Crown's promise to all of the First Nations who were parties to the treaty that they would not be molested or disturbed in the possession of their lands. Thus, they first agreed to surrender those lands to the Crown. The meeting at Niagara and the Treaty of Niagara were watershed events in Crown First Nations relations. The treaty established friendly relations with many First Nations who had supported the French in the previous war. It also gave treaty recognition to the nation-to-nation relationship between the First Nations and the British Crown, Indian rights in their lands, and the process to be followed when Indian lands were surrendered. Next screen, please. That is the belt that Art Patagos was a picture of the belt. And that comes up as a report of the Ipperwash Inquiry. You will remember that Dudley George was killed in September 1995 at Ipperwash Park. You will remember that for years the government refused to call an inquiry, and you will remember that shortly after the Liberals were elected under Dalton McGuinty that this inquiry was called. So there you have Dudley George dying, dead, in a provincial park in Ontario, and this inquiry report is talking about this belt. That's how fundamentally important the Treaty of Niagara, the foundational relationship between First Nation peoples and the Crown is in this country. And that's evidence of people of inquiry. Next screen, please. I consider this one of the most important single statements by any judge in the history of this country. This is Chief Justice McLaughlin in the Hyde Nation case. Put simply, this is the highest judge in Canada. She's retired less than a year ago, at age 75. She wrote this case in 2004. Put simply, Canada's Aboriginal peoples were here when Europeans came and were never conquered. Many bands reconcile their claims with the sovereignty of the Crown through negotiated treaties. Others, notably in British Columbia, have yet to do so. The potential rights embedded in these claims are protected by Section 35 of the Constitution Act 1982. The honor of the Crown requires that these rights be determined, recognized, and respected. This in turn requires the Crown acting honorably to participate in processes of negotiation. While this process continues, the honor of the Crown may require to consult and, where indicated, accommodate Aboriginal interests. Next screen, please. And there is the Constitution Act, Section 35. You will remember that windy day in April 1982. Queen Elizabeth and Mr. Trudeau. It was a windy day because there's a kind of a famous picture of it. And this is the repatriation of the Constitution coming home to Canada. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Just hold on that screen for a moment. In the Constitution of Canada, there's a statement that actions begins, whereas Canada, and it goes on to say that the Constitution is the supreme law of Canada. It is the highest law in this country. There is no law higher. And that's why this discussion today, and Sarah, thank you very much for organizing it. It's of fundamental importance. It's the highest law in the country. It's the Constitution. It's what weaves and brings us together, the settlers and the original peoples of this country. This is a statement that affirms and recognizes their rights. Next screen, please. This is the question that was before Justice Hennessy Court. The plaintiffs moved for a declaration that, considered apart from the pleaded defenses based upon statutes of limitations, res judicata, laches, and acquiescence. Since 1850, the Crown has been and remains legally obligated under the Robinson-Huron Treaty of 1850 to increase the annuity under the treaty from time to time if the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss, and that the size of the increase of the annuity is not limited to an amount based on £1 per person. That was about $4 in 1874, $4 per person. And Mike Bristol has already read that clause to you. That's the fundamental question before the judge. Turn the screen, next screen. There were some subsidiary questions before the court dealing with other things that the court might touch on. I just brought up those two A, B, C, D, and E subset questions up. But it's still, as Mr. Rastool explained, it's a phase one, stage one question. Is there a legal obligation enforceable by a court ruling? That's where this litigation is right now. Next screen, please. I'd like to speak about something that is called the insidious cancer of delay in resolving Indigenous legal and justice issues. Chilcotin is a decision that came out in 2007. The action, and these are the people in Chilcotin. There's no treaty there in British Columbia, and the ruling came down in their favor that they held Aboriginal title to their lands. They started the case in 1990. The separate case started in 1998. The trial started in 2001. It was set in 2001. It began in 2002. 339 trial days. The decision November 20th, 2007. This is British Columbia. This case went right to the Supreme Court of Canada. Next screen, please. This is just the index from this case. I thought you folks would like that. That's one of my favorite little, that's one of my favorite little screens. There is a tremendous burden on First Nation peoples in this country to prove rights that they come into our native court system. That decision dealt with flowers, it dealt with rocks, it dealt with sacred places. There were geologists, both botanists. The amount of proof that First Nation peoples must bring into a court case is an incredible burden on them. Next screen. And here's good old Judge Vickers. We have to honor him because he passed away. So here's Judge Vickers. At the end, this is paragraph 1373. He's sitting there. He says, I confess, he's writing this. I confess that early in this trial, perhaps in a moment of self-pity, I looked at the legions of counsel. There are only 39 lawyers. You know, let's field a couple football teams for that, but you know. I looked at the legions of counsel and I asked if someone would soon be standing up to admit that the Chilcotin people had been in the claimed area for over 200 years, leaving the real question to be answered. My view at this early stage of the trial was that the real question concerned the consequences that would follow such an admission. Your Honor, we've been around for 200 years, or maybe 2,000. I was assured that it was necessary to continue the course we were set upon. My view has not been altered since I first raised the issue almost 5 years ago. And then he's right near the end of his decision here. Go to the next screen, please. Honestly, I didn't know what Holden Wapelche was coming here, but I always know that there's going to be Wikwemikong people. And I feel that this is important. Wikwemikong is a beneficiary. They're the largest group of beneficiary holders under the Robinson-Huron treaty litigation. And I just thought that people in here today should understand that under this concept of delay and justice delayed is justice denied is the Wikwemikong Declaration of 1975, signed by then Chief Ron Wakajijic, since passed away, and his council members at the time. August 1975, 25, that's year 2000, that's 25 years, and another 19 years, 44 years ago. Next screen, please. This is the work that Chief Holden Wapelche and his people have put in since 1862. I'm trying to explain here that while it's related to the Robinson-Huron Treaty, we have to have an understanding in this area of Ontario just how long it takes to bring these cases forward. Look at the work that Wikwemikong is carrying out on its islands claim, and Chief Belche and his people are continuing negotiations. This should be updated because now Canada is involved in negotiations along with Ontario, so that screen could be updated from the year 2016. And they're working very hard at reaching an agreement in principle. But that's 44 years. But it's longer than that because it began in 1862, when Wikwemikong unceded people did not sign the Manitoulin Treaty of 1862. Next screen, please. And I thought that it was very important to say that Wikwemikong people have lives. They have children and families. They come from families. And they pass into the spirit world. And there's 5 names. Next screen. The Algonquins in Ontario have been negotiating and working at it for 43 years. Since 1975, they still don't have an agreement with Ontario or Canada. They have an agreement in principle. The purpose of the other screen and the name of those 5 Wikwemikong people was to say that these people in this room work on these things. They have lives. And I say, they shouldn't have to go to the spirit world, if at all possible, without these claims being resolved. They've waited too long. They've lost too much along the way. So let's go to the next screen. This is an extremely important statement by former Justice Binney, who said in the Mikisew Cree case that the fundamental objective of the modern law of Aboriginal and treaty rights is the reconciliation of Aboriginal peoples and non-Aboriginal peoples, and the respective claims and interests and ambitions. It is about reconciliation. It's not a word. It's about reconciliation. Next screen, please. Now, you can try to guess who wrote that. Maybe the writers in the room. Reconciliation. This is all in the past. Why should we have to pay for it now? Treaty rights are so vague as to be meaningless. Why should Aboriginal people have these rights? Wasn't this all settled in the Indian Wars? Why should there be two sets of laws? One for us, one for them. What's so special about the Royal Proclamation and the Treaty of Niagara? Why honor the treaties anymore? Or anyway, why can't they just learn to adapt and assimilate, as all newcomers to Canada must do? Maybe some of them should just think of moving away. And Binjabayong is an Ojibwe term that means where we come from. Next screen. Back to Ipperwash. One of the lessons of Ipperwash is the realization that all of us in Ontario, Aboriginal and non-Aboriginal, are treaty people. I'm on the side of the treaty. I'm on the side of the Robinson-Huron Treaty. I'm on one side of it. I was represented by the Crown. I'm a non-native person. I've gained rights and benefits through that treaty process, and there's responsibilities. There's two sides to the treaty. We are all treaty people. Next screen, please. These are important principles about how you interpret a treaty. You just don't read 3 pages of the Robinson-Huron Treaty and say, I figured it out. I read it in English, or I read Reba's translation, or Ojibwe back to English. It's much more. That's why Mike is explaining. There's lots of evidence. So the court tells us, here are the principles, and we'll go to the next screen. Treaties constitute a unique type of agreement. They attract special principles of interpretation. They should be liberally construed, and ambiguities or doubtful expressions should be resolved in favor of the Aboriginal signatories. The goal of treaty interpretation is to choose from among the possible interpretations of common intention the one that best reconciles the interest of both parties at the time the treaty was resolved. You can be sure that Justice Hennessy is working very hard on that treaty interpretation principle as she works through her decision. In searching for the common intention of the parties, the integrity and honor of the Crown is presumed. And I'll let you read principle number 5. We'll go to the next screen. Principles 6, 7, 8, and 9, and these are taken right from the Supreme Court of Canada decision. These are the rules of the treaty interpretation. This is why Jim Morrison gave evidence and gave the background. This is why the Treaty of Niagara was connected in 1764, why it relates to 1850. This is why events after the treaty are important. What did Robinson do? Well, he went down to Penetanguishene. He met with Wissahickon people. He met with Shawnee people. September 16th, 1850. They signed onto this treaty. Then he went to Toronto. Then the people from Wissahickon and Shawnee went and saw him in November of 1850 and said, Mr. Robinson, we got ourselves a little issue to talk about. And all of these are things that happened before a treaty, during a treaty, after a treaty. These things are important. Here's the front cover of the Canada's Residential Schools report, Truth and Reconciliation Commission of Canada. I was just trying to get to this notion of reconciliation, and let's go to the table of contents. Introduction, and then it says the challenge of reconciliation, Indigenous law, truth, reconciliation, access to justice, from apology to action, Canada and the churches, education for reconciliation, public memory, dialogue, the arts, and commemoration. We are all treaty people, Canadian society and reconciliation, and then calls to action. Next screen. And this is the commission telling us, and the report's only been out about 2 years. It's still a fresh report. The United Nations Declaration on the Rights of Indigenous People is the framework for reconciliation at all levels and across all sectors of Canadian society. That's the commission setting out what it believes are the guiding principles that will assist Canadians move forward. First Nations, Inuit, Métis people as the original peoples of this country and as self-determining people have treaty, constitutional, and human rights that must be recognized and respected. Reconciliation is a process of healing relationships that requires public truth, sharing, apology, and commemoration, and acknowledge and redress past harms. Next screen, please. And I'll let you read through the other point 4 and 5 about reconciliation, how it requires constructive action on addressing the ongoing legacies of colonialism, on how we must create a more equitable and inclusive society by closing these gaps between Aboriginal and non-Aboriginal Canadians. Next screen, please. Yes, okay. How number 6, all Canadians as treaty people share responsibility for establishing and maintaining mutually respectful relationships. And then you see principles 7 and 8. And we'll turn now to the next screen, please. Reconciliation requires political will, joint leadership, trust building, accountability, transparency, as well as a substantial investment of resources. It requires sustained public education. Thank you, Sarah, for organizing this conference again. And dialogue and engagement about the history and legacy of residential schools. This is a report about residential schools, and one of their principles is about we need more knowledge about treaties and Aboriginal rights and historical and contemporary contributions of Aboriginal peoples to Canadian society. Next screen, please. And that's with which, and I just wanted to close with this final thought. We all bring something into this circle as people living together. But I can't overemphasize how important it seemed to me as a former judge, now a practicing lawyer, how constitutional legal rights and the highest law of the land, we have to find answers to these questions. And we have to uphold rights that we have to find a way to secure justice in a more timely fashion, because we're dealing with the most important rights in the country. Because the Constitution, that's where our Canadian Charter of Rights and Freedoms is too. That's important to all of us. So the law is connected into the Constitution of Canada and very much is connected to the history and the relationship between First Nation peoples and the settlers, the newcomers, the rich.
There's anyone that needs a seat, there's a bench right here, and you can come and sit down if you like, before we get into the discussion.
Yeah, if anyone, we have about a half hour left. I mean, we went through all of the panelists' presentations. I'm just wondering if there's anyone who would like to lead us off with their question in general to the panel, and perhaps the specific presenter.
Hi there. Thank you very much. Thanks for the presentation. Thanks for the gathering. My name is Ron Mulholland. I'm a prof in management here at Laurentian, and I teach an MBA course in corporate social responsibility and relationships between mining companies and First Nations. So we're all trying to learn a little bit more about this issue. So the question I have is kind of a big one. I'm sure in 2014 when you filed the claim, you really didn't understand what the process would be or who the judge would be or how it would proceed. And I don't think we can understate the importance of this decision. Just as an example, it's kind of common knowledge that the Sudbury mining camp has produced about $1 trillion worth of minerals since its inception. And I don't want to talk about sort of the value, but I'm just wondering from the perception of Mike and perhaps Elder Art, how are you feeling about the process that has taken place? And talked about, or Stephen mentioned that or Mike mentioned that the judge had participated in the sweat lodge ceremony. I wondered if you comment on the process and how you're feeling about it to this point.
In the process side, the entering into the making of the treaty, we visited with Great Britain back in 1978. The came together in Ottawa. They were talking about appreciation of the Constitution of America. And I was down there at that gathering as a young chief. And I recall at that time saying that we are nations. Fred Kelly at the time was working as a administrator. And I was saying at that time, I came here to talk about the making of the Constitution. And up to this point, we've wasted our time. But following that gathering, we came up with our own proclamation. And we came up with this declaration, we are nations. So when we look at that declaration, we don't ask for permission. We just come out and assert, because that's who we are, that's what we are. When we go to Great Britain to sit down and enter into the making of a treaty, there's two sides to that one. One of them is being sovereign, where you don't go to the Canadian court for resolution. Unless you include in your agreement saying so, that you will go to your own domestic court to resolve differences. That has been left out. But entering into the making of the treaty is fundamental to the settlement of the land. There's a section in the British North America Act which talks about Section 109. Section 109 says, agreements that have been made by Great Britain with the nations must be upheld and honored by Canada. Great Britain, the motherland, says to its own child, you have obligation to sit down with these people and fulfill the agreement. So Canada is obligated. So we can take some faith in going into their court to sit down with them to come to resolution. It means we're having to step aside and move over into this house, where we'll trust the idea of what was common enough. Justice is above the law. So we look at sitting down with the people that entered into the making of the agreement, those that have inherited. Canada has inherited the responsibility and obligation. And Canada is now charged with the responsibility to deal with the making of any new treaty. Not the provinces. Provinces are a lower order of government. But Canada is a state. So when we sit down with Canada, we're having to acknowledge and recognize something. Canada was taken to court before a panel this past August. Canada was asked a question, a number of questions, asking them, what is your language? Canada has no language. It has a board language, which it has made into its own. Two, English and French. But it doesn't have its own language. Do you have territory? Again, Canada says, no, they have no territory. We have territory. So when it comes down to sitting with us, Canada's having to make the admission. It's through the treaty process that Canada gets access to territory. We give them that. But as a result of gaining access there's obligation attached to that access. That's in part what Mike talks about. The negotiation of how money is to be provided in compensation for getting the access to those resources and land. So when we sit down, Canada's asked another question. Show us your longevity tie to the land. Canada can again not show that. But we are able to do that. Long tie to the land, language, territory. International law says these are the parameters which define your being a nation. We have that. Canada does not. So Canada gains access to the making of that treaty. So when we sit down with them, we remind them, and this is the part why we go to the court. We have to hold the maker of the treaty to account, to its own law. So this is the part where the justice is talking about answering that question. Can we bring before this court this case such that it's justiciable? And we're saying yes. We're asking you to take that responsibility to make it so. But it cannot be done arbitrarily. It has to be the justice system that accepts and openly declares that it will. That's the way law operates. Entering into the making of a treaty, or at least some difference. Right now, Canada's gone through this, okay, with the United States about where they want to go to court. Come to Canada or in the States, where does the infraction occur? On the state side, or we'll go into the Canadian court, or the end up creating a second independent tribunal. We have not asked for that. We can. But if you're going to go into another arena, you run the risk of not having teeth in that body. So with Canada, we're saying the justice system has teeth. Because the law is there. Enables itself to the making of law, to give itself the teeth so that it can make decisions about how to decide disputes when they arise. So we trust, as we did when we entered into making the treaty. There are areas that are yet gray and uncertain. But when we entered into the making of the treaty, the people were asked, I will put my faith in the understanding that I will not be cheated. I will put my faith in the understanding that I will not be hurt, but I will be treated with fairness, and I will be accepted as a person. Not a half person, but as a full human being. So when we deal with these matters, okay, those are the kinds of areas where we visit. We put ourselves at the mercy, with the understanding that outcomes will come, but they're not going to be ones that are going to cause us pain and suffering. They're not going to deprive us and treat us as though we don't belong. It will take a look at you in terms of what is going to be in your, as the law describes in some cases, your best interest. In a treaty, that kind of word is used when it talks about the taking of land and the selling and use of the resources. It will get for you the highest possible return, as you would expect if you're entering into business operations. You produce that for your investor, so that your investor will be secure in decisions where it makes investment about putting its life at risk. It's internet risk. It's home at risk. So as people, we put ourselves in that position. There's a risk involved. But it's one which we're willing to take because we trust that the human will make a good choice. So that's the kind of path we follow. We're saying we do not need an independent body. We can use what exists, the Canadian justice system.
Okay, good. What can you say after that? What else is there to say? You know, you can appreciate the frustration of the First Nations people having followed this grievance for 144 years to today when we were finally waiting on the court to make a decision for justice under our treaty. When I did my presentation, I talked about a little bit about the principles that were introduced in court and were explained by the elders. We talked about respect. When we talk about respect, if you've done any of the readings, if you know what people said to each other in the past, Indigenous peoples in this land, when they discuss things with higher authorities in amongst the British people, always referred to those men as father when they addressed them. That didn't mean that the Anishinaabe people or the Indigenous people were saying, "You are now my father." They were using that as a term of respect for those people. In the same way as when Justice Hennessy or Stephen are in the courtroom, we address them as Your Honor because we show them the respect that we do that. We expect that the same respect would be given to us. And that's why we call our leaders chiefs, Ogima, because we respect those people. And we respect elders. When I refer to Art, I say, this is Elder Art Patheticus. You know, so that's the kind of thing that the elders talked about in court in terms of respect. Generosity, we know that the Indigenous people always held that high in esteem, that value of generosity. They shared. If the European people coming across and landing on the territory, if these people didn't have any value in generosity and respect, there would have been a war there. Those people would not have landed on the shore. So those kinds of things are important. Reciprocity, if you give me something, I will give you something back. And that's the way it was. One of our esteemed elders, Gordon Wendemans, always talked about how Indigenous people respected each other's territory. If a Huron person came to Ojibwe territory, there was a protocol that a Huron person or a Huron people would come to the Ojibwe people and say, "We'd like to come into your land. Why? We're looking for game. We want to sustain ourselves. We want a share of your land so that we can, you know." And when they do that, they give something back, and there's a sharing. It's a reciprocity. Renewal. Everything needs to be renewed over the years. We need to talk about that. If you listen to Alan Corbier when he talks about the treaty belts, very often he will say that belt needs to be shined. It needs to be renewed so that people continue with that understanding about the sharing between them, the respect, the reciprocity. And sharing, obviously, that is a big value amongst Indigenous people, and so it is with non-Indigenous people as well. That's part of our case because it's important that in 1850, when the Ojibwe people said, "Yes, you can come in and use this land," Chief Shinwa Combs said to William Benjamin Robinson, "Yes, you can use this land, but you need to give us a share of what is here." And that's that share of that land is that annuity that we're fighting for. That's the reason why we're in court. Those are the things the values that we're taking into the court, to ask the court to understand those kinds of things from the Anishinaabe perspective. That's what we're fighting for in the case. Which,
I don't think I have anything to add to Bernard, although I think there probably might be a few other questions at this time.
Zona Gov Edition Class Chief McLeod from Ipsing. I guess I just want to comment and maybe add one of Justice O'Neill's slides that showed the 5 names of the individuals that were gone. In my community alone, and not even to begin to think about one of the larger communities that Pelche is from, we have hundreds, thousands of people, generations of people that will never see the benefit of what was promised. They're gone. When we put it in perspective, the annuities case is, in my opinion, it's not going to be that big of a victory in one sense. Because if you think about it, if, just to put it in simple terms, if somebody stole your car and many years later you just get back the tires, is that a victory? And the person doesn't go to jail for doing it either. So that's not a victory in my mind. The victory, I guess, would be setting the record straight and where do we go from here on forward into the future. And that's the victory, and that's the fight that we're fighting for our children currently in our schools and our children that are not here yet is where we go from here and moving into the future. We're not going to throw a big party about getting those tires back. But essentially, I'm just trying to give you a perspective of our view of this, my community's view of this, because when you think of how much money is involved in just the $4 of all the people that have been part of my community since the late 1800s, just the $4 in today's value, right? That's a lot of money. And then you add on the trillions of dollars that this province has made out of this agreement. It's a number that Ontario or Canada will never be able to deal with because they've pushed it off for so long. So any amount of money that we do get out of the annuities claim is like I say, it's going to be tires or even less. So that's just to put it in perspective. And Ontario, the people of Ontario, the people of Canada have benefited from that since the signing of the treaty. And that money, that value, we're never going to get it back to First Nation communities. But we have to set the record straight, and we have to move forward, and we have to make the environment better for the people that are to come after us.
Any other questions? Okay, I see one. I just wanted to mention briefly too that I know Sarah put a lot of work into putting this panel together, and she tried very hard to make sure we were gender diverse. And as you can see, it's a mammal is the new term, all man. And I apologize for that. And it's through no lack of effort on Sarah's part. She reached out to many people in the community to make sure that we had some diversity. And so I was really hoping the last word would go to a quite.
I don't have much of a question, but I just want to say that this panel has been really, there's a lot of diverse speakers, and listening to Art's wisdom and Mike's view made me really understand, and especially Stephen, your breakdown of it, it really opened my eyes as I'm in first year in Laurentian. And perspective, I was just making a joke with my friend is that we're not even gonna get the tires back, we're just gonna get the bolts. But speaking of respect, his perspective as well really struck a chord within me, and I thought, what a shame. What a shame that we're only getting so much back. And it made me think of my daughter and how much of it is a shame for her that she gets only so much respect from public education. So to other people's eyes, it's not just about the treaty. This goes back to many generations, and I can trace my generation all the way to 1700s, and to see all that hurt in my family, in my ancestors, it really struck a chord within me, and it just hurts. But to see this being done we're not going to get a big return for it, but it's something. It's the sort of something bigger for us. Any questions? Oh.
So we're at 3:45. We'll take a quick break.
Very quick.
Okay.
Rich, just one question for my good friend, Honorable Stephen O'Neill. At the time of treaty making in 1850, I know in my community I've asked the elders if there was a word for surrender. And in your opinion, your professional opinion, how would that translate to what we're talking about, the treaty principles that are from the Supreme Court? And if because I keep hearing too that there's surrender language in these treaty documents, there's surrender terms, but how does that translate to from the perspective of the Nishnawik?
Thank you, Rich Overmapalche. First of all, I want to say, first of all, I am a retired judge. If I were a practicing judge now, I would be the Honorable Mr. Justice Stephen O'Neill. But when you retire and you go back to be a lawyer, you're just the Honorable. Kind of the Honorable. But I want to be clear that I'm no longer a judge and I am a lawyer. But and I also want to say we have to be very respectful of the court process as everyone waits the decision. Ontario's waiting, Canada's waiting, First Nation peoples are waiting, and that's a very important process to respect. Chief Peltier has asked a very, very hard and learned question about the word surrender. It's a word that's starting to come into a few court cases. The Keewatin case went to the Supreme Court of Canada. We see some of this language coming into the Supreme Court writings. But I'm going to sort of say off the top of my head that we really don't have a definitive ruling on this concept of surrender. Because the First Nations people that I've worked with, who have taught me so much, the teachings, and every day there's a teaching, which for your teachings, they don't see it that way. Niagara, the Crooked Place, Niagara, 1764, when people will read about this, they're not going to get that concept necessarily of a surrender. But the word is beginning to come into the court lexicon, the lexicon of the court a little bit. There's been no, as far as I'm aware, really no test case on what this really means. Why is that word used? How did it, we can trace it, we can look back and see where it first started coming into the language. But surrender doesn't conjure up the right image for some of us. Surrender language. Because it's a treaty-making process. There's a two-row wampum and a covenant chain. There's nation to nation. So how did that word fit in? Now, I'm not certain whether the judge will or will not address some aspects of that in Palisade, so I'll just respect waiting judge's ruling on how this word may or may not be addressed in a writing. not certain, I don't know, but, I think Chief Palche is really saying that in a nation-to-nation treaty-making process involving reciprocity, respect, generosity, sharing, how does that work in there? And we don't have too much guidance about that yet in our Supreme Court of Canada or Court of Appeal decisions. The word is coming into the writings, but it's just coming in the last 10 years, and we don't have really clear guidance about it yet. Rich.
Okay, so it is, I'm just gonna get over to this one. I think we're gonna have to close it up. I'm really sorry if there are questions, but we're about 10 to 4, and I know that there are people who need to get to class, including our moderator. And so I'm just gonna say a quick thank you to start off with saying a quick thank you to Brock so he can slip out.
Let you step off to class. So thank you so much
for moderating for us and participating in the panel. And so I do want to say chimigwech to the members of our panel. And as I said already, to our moderator who, and I'd also like to thank everyone who joined us via live stream and everyone here in the audience. And again, I do apologize if you had questions and didn't have a chance to have them answered. We are going to have this recorded and posted on our website for future use and viewing. And I also want to say a quick miigwech to the University of Sudbury staff who helped make this panel possible. Sylvie Renault, Sarah Noel, Cassandra Rees, Felix Halle-Thorett, sorry, Marianne Sagan, Denis, Jeanette Trottier, Linda Bollier, Patrick Picard, and the maintenance crew, Wayne and Richard, who set up the venue for us. And I also want to say a quick miigwech to Benesha McLeod, who volunteered last minute to help us set up as well. And so with that, I invite you all to take advantage of whatever's left at our refreshment tables over there. And again, thank you so much for coming and participating in our panel.